A law from 1974 says political parties can only spend a limited amount of money in coordination with their own candidates. For Senate races, it's about $58,000 per candidate. For House races, even less. The idea was to prevent corruption, stop big donors from routing unlimited money through party committees to candidates. In 2001, the Supreme Court upheld this law, 5-4. But on December 9, 2025, the Supreme Court heard arguments to overturn that precedent. The National Republican Senatorial Committee, the National Republican Congressional Committee, and Vice President JD Vance are asking the court to strike down these limits as unconstitutional violations of free speech. The case is National Republican Senatorial Committee versus Federal Election Commission. It's pending right now. Decision expected by summer 2026. And if the challengers win, it could blow open the floodgates of party-coordinated money in federal elections. No more limits. Parties could spend millions, tens of millions, hundreds of millions in direct coordination with candidates, all perfectly legal. This isn't just about campaign finance. This is about whether money is speech, and whether corruption is something courts should worry about. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal is how a Supreme Court decision expected in 2026 could fundamentally transform how campaigns are funded and potentially make candidate contribution limits meaningless. Hit that subscribe button right now because this case affects every federal election going forward. Here's what's happening and why it matters. The Federal Election Campaign Act, FECA, was passed in 1971 and amended in 1974 after Watergate. It created contribution limits. Individuals can contribute a limited amount to candidates. Currently, it's $3,300 per election. The purpose is to prevent corruption. If one person can give a candidate $10 million, that candidate becomes beholden to that donor. That's quid pro quo corruption. You give me money, I give you favors. FECA also created limits on coordinated party expenditures. A party committee, like the NRSC or the Democratic Senatorial Campaign Committee, can spend money in coordination with a candidate. But there's a limit. For Senate races, it's based on a formula, currently about $58,000 per candidate. For House races, it's much less. Why limit coordinated party expenditures? Because without limits, donors could circumvent the contribution limits. Here's how. A donor is capped at $3,300 to a candidate, but the donor can give $41,300 to the National Party Committee. If the party can then spend that money in unlimited coordination with the candidate, the donor just routed $41,300 to the candidate through the party. The contribution limit becomes meaningless. So FECA limited both direct contributions and coordinated party expenditures. But FECA allows unlimited independent expenditures. If the party spends money independently, without coordinating with the candidate, there's no limit. That distinction, coordinated versus independent, is key. In 1996, the Supreme Court decided Colorado Republican Federal Campaign Committee versus FEC, Colorado FERS. The court held that parties have a First Amendment right to make unlimited independent expenditures. You can't limit independent spending. That's protected speech. But the court left open the question of coordinated expenditures. In 2001, the Supreme Court decided FEC versus Colorado Republican Federal Campaign Committee, Colorado II. Different case, same parties. This time, the court addressed coordinated expenditures, and the court upheld the limits, 5-4. Justice Souter wrote the majority opinion. The court said coordinated expenditures are functionally indistinguishable from contributions. If the party is coordinating with the candidate, the spending is as useful to the candidate as cash. The candidate knows the party is spending on their behalf. The candidate can direct how that money is used. That creates a risk of corruption. Donors can use the party as a conduit to the candidate, so Congress can limit coordinated expenditures to prevent corruption. Colorado II has been the law for 24 years. But now, the NRSC, NRCC, and JD Vance are asking the Supreme Court to overrule it. They filed suit in 2022 in the Southern District of Ohio. They argued that Colorado II is no longer good law. The legal landscape has changed. The factual backdrop has changed. The limits violate the First Amendment. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the oral arguments from December 9th and explain which justices seemed sympathetic to overturning Colorado II and which justices wanted to preserve it. Subscribe right now so you don't miss it. The District Court certified the constitutional question to the Sixth Circuit. The Sixth Circuit, sitting en banc, upheld the limits. Chief Judge Jeffrey Sutton wrote the opinion. The court acknowledged the legal landscape has shifted since Colorado II. Citizens United, McCutcheon, Ted Cruz for Senate. All of those cases narrowed the anti-corruption rationale. But, Sutton said, the Supreme Court hasn't overruled Colorado II, and lower courts are bound by Supreme Court precedent until the Supreme Court itself overrules it. We can't predict what the Supreme Court will do. We have to follow Colorado II. Several judges wrote concurrences expressing doubt about Colorado II. Judge Amelthapar said under the current legal landscape, the limits should fall, but he agreed the panel was bound by precedent. Judge John Bush similarly cast doubt on Colorado 2, but Judge Jane Branstetter Stranch wrote a concurrence defending Colorado 2 on the merits. She said the majority was wrong to cast doubt on it. The coordinated expenditure limits serve important anti-corruption purposes. The NRSC and others petitioned the Supreme Court. On June 30, 2025, the court granted certiorari. And here's where it gets interesting. The FEC declined to defend the constitutionality of the limits. The FEC, the defendant, said the limits violate the First Amendment. The FEC agreed with the challengers. So who would defend the law? The Democratic National Committee intervened. The DNC filed a motion to intervene to defend the limits. And the Supreme Court appointed an amicus curiae to argue in support of the judgment below. On December 9, 2025, the court heard oral arguments. The challengers argued that Colorado 2 should be overruled. They said the First Amendment protects the right of parties to speak in coordination with their candidates. Parties and candidates are part of the same political movement. Limiting how much they can spend together limits their speech. And under Citizens United, independent expenditures can't corrupt. If independent spending is protected, why isn't coordinated spending? The argument is that coordination makes speech more effective, not more corrupting. If I'm the NRSC and I want to support a Senate candidate, I should be able to coordinate with that candidate to ensure my message is effective. If I spend independently, I might duplicate the candidate's efforts or send conflicting messages. Coordination makes the speech better. The challengers also argue that the factual predicate for Colorado 2 has eroded. Colorado 2 assumed that coordinated expenditures would be used to circumvent contribution limits, but that hasn't happened on a large scale. Parties haven't exploited coordinated expenditures to funnel unlimited money to candidates. So the corruption rationale doesn't hold. The defenders of the law argue that Colorado 2 should be preserved. They say coordinated expenditures are contributions in disguise. When a party spends money at the direction of a candidate, that's functionally a contribution. The candidate controls how the money is spent. The candidate benefits directly, and big donors can use the party as a conduit. Without limits, a donor could give $41,300 to the party with the expectation that the party spends it to benefit a specific candidate the donor favors. That's corruption, or the appearance of corruption. The defenders also argue that Citizens United doesn't undermine Colorado 2. Citizens United was about independent expenditures. The court said independent spending can't corrupt because there's no coordination. But Colorado 2 is about coordinated spending. That's different. Coordination creates a relationship between the donor, the party, and the candidate. That relationship creates corruption risk. Now, quick legal note. This is educational information, not legal advice. This case is pending. We don't know how the court will rule, but the oral arguments give us clues. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 people who stay informed about cases that could change how elections are funded. Click subscribe. Now let's talk about what the justices said at oral arguments. The conservative justices seemed skeptical of the limits. Chief Justice Roberts asked whether coordination really increases corruption risk. If a party wants to help its own candidate, why is that corrupt? The party and the candidate share the same goals. Justice Alito asked whether the limits violate the party's associational rights. Parties have a First Amendment right to associate with their candidates. Limiting how much they can spend together burdens that right. Justice Kavanaugh asked about the effectiveness of speech. He suggested that coordinated speech is more effective, and more effective speech is better for democracy. Justice Gorsuch raised questions about whether the limits are narrowly tailored. If the concern is circumvention of contribution limits, are there less restrictive ways to address that? The liberal justices defended the limits. Justice Sotomayor emphasized the corruption concern. She said without limits, donors will route money through parties to candidates. The contribution limits become meaningless. Justice Kagan pointed out that the limits have been on the books for 50 years. Congress enacted them, the court upheld them in Colorado too. Overturning them would disrupt settled expectations. Justice Jackson asked about the practical effects. She wanted to know what would happen if the limits are struck down. How much more money would flow into elections? The oral arguments lasted about 2 hours. Court observers said the conservative majority seemed inclined to strike down the limits, but the justices also seemed concerned about the implications. A decision is expected by late June or early July 2026. Now let's talk about what's at stake. If the court strikes down the coordinated expenditure limits, here's what could happen. First, parties could spend unlimited amounts in coordination with candidates. Right now, the NRSC can spend about $58,000 per Senate candidate in coordinated expenditures. If the limits are struck down, the NRSC could spend $10 million, $50 million, $100 million per candidate, all coordinated, all directed by the candidate. Second, donors could circumvent contribution limits. A donor can give $3,300 directly to a candidate, but the donor can give $41,300 to the National Party Committee. If the party can spend that money in unlimited coordination with the candidate the donor favors, the donor just routed $41,300 to that candidate. Third, campaigns become even more expensive. Candidates would rely on parties for massive coordinated spending. That creates pressure on parties to raise more money, and parties would become even more beholden to big donors. Fourth, the role of parties changes. Parties would become conduits for big money, not independent political organizations. Fifth, corruption risk increases. When parties can spend unlimited amounts in coordination with candidates at the direction of big donors, quid pro quo corruption becomes more likely. And sixth, candidate contribution limits become less meaningful. If donors can give unlimited amounts through parties, the base contribution limits lose their anti-corruption function. This information could literally determine how much money flows into the next election and whose voices get heard. Subscribe now because my next video will explain exactly what happens to other campaign finance laws if this precedent falls and which restrictions are likely to be challenged next. Hit that subscribe button. Now let's talk about Citizens United. The challengers rely heavily on Citizens United versus FEC from 2010. In Citizens United, the Supreme Court struck down limits on corporate independent expenditures. The court held that independent expenditures do not corrupt or create the appearance of corruption. Why? Because there's no coordination. The candidate doesn't know the spending is happening. The candidate can't direct it, so there's no quid pro quo. The challengers say if independent expenditures can't corrupt, coordinated expenditures shouldn't be treated as corrupting either. The only difference is coordination. And coordination just makes speech more effective. But the defenders say Citizens United supports Colorado too. Citizens United explicitly distinguished independent expenditures from contributions. The court said independent spending is different because there's no coordination, but coordinated spending is like a contribution. It involves a relationship between the spender and the candidate. That relationship creates corruption risk. So Citizens United and Colorado too fit together. Independent spending is protected. Coordinated spending can be limited. The challengers also cite McCutcheon versus FEC from 2014. In McCutcheon, the court struck down aggregate contribution limits. An individual could give to as many candidates as they wanted. The court said aggregate limits don't serve an anti-corruption purpose. They just limit participation. And the court emphasized that only quid pro quo corruption justifies limits, not just the appearance of corruption, not unequal influence. Only actual quid pro quo. The challengers say coordinated party expenditures don't create quid pro quo corruption. The party is spending its own money. The candidate isn't receiving a direct benefit from a donor. The corruption chain is too attenuated. But the defenders say McCutcheon doesn't help the challengers. McCutcheon was about aggregate limits. Colorado 2 is about coordinated expenditures. Those are different. Coordinated expenditures create a direct relationship between donors, parties, and candidates. Donors give to the party expecting the party to spend on their preferred candidates. That's quid pro quo. And they cite FEC versus Ted Cruz for Senate from 2022. In Cruz, the court struck down a limit on post-election repayment of candidate loans. The court said the limit didn't serve an anti-corruption purpose. It was just a burden on candidates' ability to lend to their own campaigns. The challengers say Cruz shows the court is serious about limiting anti-corruption justifications to actual quid pro quo. And coordinated party expenditures don't involve quid pro quo. But the defenders say Cruz is distinguishable. Cruz was about a candidate's own money. Colorado 2 is about donors using parties to route money to candidates. That's different. Look, I spend hours every week tracking campaign finance cases, analyzing Supreme Court oral arguments, and explaining how these decisions reshape democracy. The least you can do is subscribe to make sure you don't miss the decision when it comes down. Subscribe right now, and if you found this helpful, share it with anyone who cares about money and politics, because this case affects every federal election. Now let's talk about the Wisconsin example. Several amicus briefs pointed to Wisconsin as a case study. Wisconsin eliminated its coordinated spending limits in 2015. What happened? Money flooded in. Recent gubernatorial and Supreme Court elections shattered fundraising records. Tens of millions of dollars transferred from state parties to candidate committees. The 2025 Wisconsin Supreme Court race cost over $100 million, the most expensive judicial race in American history. Why? Because candidates could coordinate unlimited spending with parties, and parties became conduits for big donors. Critics say this is what happens when you eliminate coordinated expenditure limits. The contribution limits become meaningless. Big donors use parties to funnel money to candidates. Races become more expensive, and corruption risk increases. But supporters of striking down the limits say Wisconsin shows that parties play an important role in funding campaigns. And that's a good thing. Parties can vet candidates. Parties can ensure message discipline. Parties can support candidates who share the party's values. If parties can spend more, candidates rely less on big individual donors and more on party infrastructure. Now let's address the First Amendment argument. The challengers say the limits violate free speech. Spending money to communicate political messages is speech. The Supreme Court has said that repeatedly. Buckley versus Valeo. Citizens United. McCutcheon. All of those cases treat spending as speech. If I want to support a candidate by spending money on ads, that's speech. And the First Amendment protects speech. The government can only limit speech if it has a compelling interest and the limit is narrowly tailored. The challengers say the government doesn't have a compelling interest here. Coordinated expenditures don't cause corruption. Parties support their own candidates. That's the whole point of parties. Limiting that is just limiting political speech, but the defenders say the government does have a compelling interest. Preventing corruption and preventing the appearance of corruption. Both are compelling. And coordinated expenditure limits are narrowly tailored. They only limit coordination. Parties can still spend unlimited amounts independently, so the limit is narrow. It targets the specific corruption risk, coordination, while leaving other speech untouched. Remember, this is educational information based on the pending case National Republican Senatorial Committee versus Federal Election Commission. Oral arguments held December 9, 2025. Decision expected by summer 2026. This is not legal advice. This is analysis of a pending constitutional case. The outcome is uncertain. But the stakes are enormous. If the court strikes down the limits, the campaign finance landscape changes dramatically. Parties gain the power to spend unlimited amounts in coordination with candidates. Donors gain the ability to circumvent contribution limits by routing money through parties, and the role of money in politics increases. If the court upholds the limits, the status quo continues. Parties remain subject to coordinated expenditure limits. Contribution limits retain their anti-corruption function, and the framework from Colorado the SECU stands. We'll know in a few months, and when the decision comes down, you need to understand what it means. Subscribe so you're ready, because National Republican Senatorial Committee versus FEC isn't just about one law. It's about whether campaign finance regulation is constitutional at all, and that affects every election, every candidate, every donor, and every voter in America.